Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And tonight we are going to be continuing our reading from a treatise, and the name of which is A Treatise on the American Law of Administration. The first class we got to, I think, about section 9, so we will continue our reading from there. If you'd like to join the Vocational Science Freedom Gilded server, you can do so by going to the Vocational Science Freedom Odyssey page and clicking on any of the show notes on any of the classes. And you can also go to the About section and click on the About section, and the link is gilded.gg/VSOF. And you can also find it on all of the links for all of the classes that are also on Rumble. And just as a public service announcement, as far as that's concerned, just this last week, we were kicked off of YouTube permanently, finally banned off of YouTube. So we now join the ranks of many, many other people who have been permanently banned off of that platform for speaking too much truth. Same as James Corbett, Alex Jones, and many, many others. So we are going to have all of our content specifically on Odyssey first, and it will be backed up on Rumble as well. So, okay, so with that, let's get into the treatise. I put a link to the folder for the mega folder is in chat. It will also be in the show notes in the classes as well. So if you want to open up the mega folder, and we can download the first document, which will be a treatise on American law of administration. And also, if you'd like to open up the vocabulary words as well, that's fine. You can follow along with that. And then we'll get to these other documents later on tonight. So we left off in section 9, which I think was page 183, I think, maybe. The law as the rational will of the owner. It is self-evident that the claims of creditors of a deceased person constitute a title to the property left by him superior to that of heirs, whether testamentary or at law. Yes, I'm going to read that again because that's kind of important. It is self-evident, or at least the attorney in here is saying that it is self-evident, that the claims of creditors of a deceased person constitute a title to the property left by him superior to that of the heirs. So if someone has debts when they die, their creditors have the highest title. Okay, so that's important to understand as far as this whole entire system of human trafficking and the law merchant, and that they've got us all bound to, quote unquote, pay the national debt, right? So just keep that in mind. But to continue, a debt constitutes property of the creditor remaining in the possession of the debtor, which, by the concurrent will of both, is, at some period subsequent to the creation of the debt, arising out of an express or implied contract, meaning I promised to pay you something in the past, to pass into the possession of the creditor. The debtor then has only a qualified property in the thing, usually the price for goods sold or services rendered, which constitutes the debt, namely the right of possession for a period of time which may be definite or depend upon the forbearance of the creditor, meaning whenever you sell that thing, then you got to pay me. The substantial property, the right of the thing, with a present or future right to the possession also, is already in the creditor. For this reason, it cannot go to the debtor's heirs, or it goes to them to the extent only in which he had an interest therein. To secure the rights of creditors and the estates of deceased persons against the heirs, as well as against strangers, and to secure justice to and between the heirs themselves, in other words, to enforce the rational will of the decedent, which can be no other than that upon his death his property shall pass to his creditors and testamentary or legal heirs. The law itself performs the office of the deceased owner, substituting for or supplying as his will its own universal will. Okay, now in case you don't know what that means, I'll reread it and I'll break this down for a second. The law itself performs the office of the deceased owner, substituting for or supplying as his will its own, meaning the law's own, universal will. So, meaning that the attorney will determine for you what your will is, even though it's already been written down. So that's basically what this is saying, that the law itself performs the office of the deceased owner. Okay? Now, if everything were being run properly, that wouldn't matter so much. But obviously, this whole entire system of fraud is all based in probate fuckery. So that's not exactly what is actually going on. And let me just click back up here real quick. I was going to just check the notes here. Okay, so 1 and 2 from the last page. All right, so 3, this is where the end of this is. Okay, so the character of his estate, together with the variety of individuals who may be interested in it, as creditors, legatees, or distributees, seems to demand that it also should be vested by law in some common agent who shall preserve it from waste and dispose of it to those entitled to receive it according to the provisions of the law, which has undertaken to provide for the discharge of the duties omitted by the intestate. Okay, so intestate. What's an intestate? Okay, so if you look up and go to the vocabulary words, I put intestate in here for everyone. So I scroll down past estate here, which goes on for a bit. So what is an intestate? One who, having the lawful power to make a will, has made none. Or one which is defective in form. In that case, he is said to die intestate, and his estate descends to his heirs at law. This term comes from the Latin intestatus. Formerly, it was used in France indiscriminately with deconfess, that is, without confession. It is regarded as a crime on account of omission of the deceased person to give something to the church, as was punished by privation of burial in consecrated ground. That's not really relevant. But so the point is basically one who, having lawful power to make a will, has made none. That's someone who is an intestate. Okay. So that's what they're talking about. Someone who has no will. Okay. From this aspect. All right. So which has undertaken provide the discharge of the duties omitted by the intestate. So when someone does not have a will, what's going to happen? The attorney is going to determine what's going to happen to the property. And they become basically an administrator. Now, there's a huge difference between administrator and executor, but we'll get to that in a minute. So I'll save to bring that up in a second. Let me finish this off. So the creation of this agent, the law, wisely leaves to discretion of the ancestor if he chooses to exercise it. He may make his own will instead of leaving it to the law, meaning the attorneys and the judges, to make one for him. And he may appoint his own agent or executor instead of confiding this duty to the probate court under the authority of the law. Okay, so if he makes a will and he appoints an executor, okay, it doesn't go to the probate court. It doesn't go to just the attorneys deciding whatever they want to make up, which would then they would appoint what's called an administrator. So now, if we look up and take a look at the two definitions of those two words next to each other, so you have administrator, and I'll make this a little bit smaller here real quick, so we can put executor next to it, so we can look as a side by side here, because this is important to understand what they're doing. As the fact that none of us have a lawful executor, unless of course you've done your vocational science from status doc set, and what they're doing in the system is they're running everybody through administration to administer your estate. So executor, trusts, the word executor taken in its largest sense. Well, actually, let's do administrator first. Administrator, trust. An administrator is a person lawfully appointed with his assent by an officer having jurisdiction to manage and settle the estate of a deceased person who has left no, what? No executor. Or one who is for the time incompetent or unable to act. What's one aspect of incompetency? Being labeled as an infant, right? Okay, number 2. It would be proper to consider, first, his rights, secondly, his duties, thirdly, the number of administrators and their joint and several powers, fourthly, the several kinds of administrators. So there are different kinds of administrators, and there can be more than one of them. Like, say, all of the judges in all of the inferior courts, they're all acting as special administrators. If you go look it up in the Uniform Probate Code, that's exactly what it says they are. Now, I didn't have that brought up, but you can go verify that on your own volition. Trust me, it's there. 3, by the grant of letters of administration, the administrator is vested with full and ample power, unless restrained to some special administration, to take possession of all the personal estate of the deceased. Now remember that says deceased, not decedent. And to sell it, to collect the debts due to him, and to represent him in all matters which relate to his chattels real or personal. He is authorized to pay the debts of the intestate in the order directed by law, and in the United States, he is generally entitled to a just compensation. Yeah, like the judge's 501c3 slush funds. Anyway, which is allowed him as commission on the amount which passes through his hands. Now, the aspect of administrators, there's a part of the Magna Carta. Articles 3, 4, and 5 talk about aspects of the administrators and what they're allowed to do and what they're not allowed to do. This all comes back full circle as to what they're doing, as far as the administration of the estate. Okay? All right, 4. He is bound to use due diligence in the management of the estate, and he is generally on his appointment required to give security that he will do so. He is responsible for any waste which may happen for his default. Why is it that every single court case in all of these inferior courts, I don't give it the damn if it's a traffic ticket or what, they're all bonded? Why are they all bonded? It's because of this reason. Because they have to give security. But instead what they do is they trick you. They use power of attorney to create a bond for the constructive trust, which is the court case, which protects them even though it's in your name, your estate name. Well, how did that happen? Well, it's because they're using power of attorney. And we've talked about this before, and the people that have gone and specifically requested by a state open records request act and gotten the bonding information from their cases, it shows that they are using power of attorney to create the bonds. Did they ever tell you? No. Do they have to? No. Because you're considered to be an infant. Okay? All of this presumption that they're using as far as the infancy is concerned allows them to do everything that they're doing on the administration side. Okay, so let's leave that for administrators. Okay, so now what's an executor? The word executor, taken in its largest sense, has several acceptations. Executor dativus, who is one is called an administrator to the intestate. Executor testamentarius, which is what we do. This is what we create. We make sure that we appoint ourselves this type of executor, or one appointed to the office by the last will of the testator. And this is what is usually meant by the term. So this is what we're doing. So this is why in the VSOF status doc set, we make sure that we have a proper executor appointment, because our will has already been probated. The presumption is we're already dead. And so, but in that presumption, it's all been done over here in testate and by administration, right? Which is why the enormous administrative building went up next to the White House in 1933, because they were then administering everybody. Okay. And that's all the special administrators are doing. The black robe priests of El are doing up on the bench. They're just being special administrators because you don't have a will. There's never been an executor appointed to take care of the estate. So it's all being flipped and flopped around over here. Okay. Number 2, in the civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius, which is exactly what I just said. The term executor, it is said, is a barbarism unknown to that law. What law? Roman civil law. But yet, what are they running everything through? Roman civil law, statutes, acts, ordinances, and codes. Okay, so in the civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius. Right now, we don't use that term in the doc set. We do say that you are an ares, which is another word for heir in Latin. But we don't say ares testamentarius, but because it's that saying under the civil law that you have to do this, and this is an aspect of the 12 tables, which I don't want to get into. But the reason is because they say it different. It's two different terms. Okay. So look, semicolon. The term executor, it is said, is a barbarism unknown to that law. So when you walk in there as the executor, the sole lawfully appointed executor of the estate, The civil law has no power over you. In fact, they can't even hear you, which, as far as I'm concerned, is just fine. Because I'm not telling you to do anything that's based on the Roman civil law. I'm telling you to do things that's based on the common law. And I'm giving you orders as a trustee to do so. So it's a whole different matter. And then 3, an executor, as the term is at present accepted, is the person to whom the execution of the last will and testament of personal estate is, by the testator's appointment, confined, and who has accepted of the same. So what do? We appoint ourselves executor of our estate, and we accept the same. Generally speaking, all persons who are capable of making wills may be executors, and some others beside, as infant and married women. Okay, so this is the main difference between executor and administrator. And this goes on for a bit. If you guys want to, you can feel free to look up and read all of the rest of the types of executors that there are. And you can read all the rest of the aspects of different types of administrators that there are, right? And then also a female administrator is an administratrix, but rarely do judges ever call themselves that, even if they are females. Okay, so, and remember, again, in the Uniform Probate Code, it says that they are all operating as special administrators, right? So and this is the point here. An administrator is one that's appointed by a court to an estate that has no will, that's intestate. An executor is one that is appointed by the sole lawful heir or the testator to take care of the estate by will. So one is by will, which we record on the public record, and one is just by the willy-nilly of the court because there isn't what? There isn't a proper executor. Okay? So, now that we've got that all cleared up, let's go back to the treatise. Okay, so the creation of this agent, this is the aspect of the administrator. So the creation of this agent, the law wisely leaves to the discretion of the ancestor if he chooses to exercise it, meaning if he decides to write a will. He may make his own will instead of leaving it to the law to make one for him. To make one for him. Your will has been probated. This decision has already been made for you. It's already done. What we have to do is reverse it. Okay? And he may appoint his own agent or executor instead of confiding, scroll down here, this duty to the probate court under the authority of the law. If the ancestor by will appoint his own agent or executor, he thereby becomes vested with the title to the property in a fiduciary character. Let me read that again because it's important, because this is all about title. It's all about actually who holds the fucking title. If you don't hold title, you own nothing. Whoever holds the title is the master. So let me reread this again. If the ancestor by will appoint his own agent or executor, he thereby becomes vested with the title to the property in a fiduciary character. So if you don't have a lawfully appointed executor to your estate, guess who holds the title? The special administrator. And they're going to do whatever they want with that title, including but not limited to producing bonds upon it and hypothecating it and splitting it up and putting it into various different constructive trusts and minor accounts and all the rest of the filth that they do, right? It's all about title and about standing. To continue, but if either designatingly or otherwise the ancestor die without executing his power of testamentary disposition, the law, as in case of real estate, assumes itself the duty of appointment and vests this title and authority over the personal estate in a common agent for the parties in interest, who is called an administrator. Get it? You either take control as an executor or you are being controlled by a special administrator who is the black-robed priest of El sitting up there on the bench, just taking his percentage out of your estate because all of our estates have been pledged for the bankruptcy of a filthy corporation called the United States. Number 2, this kind of continues into what I already read, but I'll just finish it off. The term administrator is in its primary signification and general sense equivalent to conduct, management, distribution, etc. Webster is also applicable to the management of the estate of minors. Right. Because we're all seen as infants. I'm going to blow this up here because I put in the definition of the term person, the aspect of the under 1 USC subsection 8 definition, person, human being, child, and individual, as including born alive infant. So remember, whenever they use the word includes or including in statutory construction, it means this and nothing else. The word includes does not mean and also. When you use the word include in statutory construction, it means only this. So, A, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapien who is born alive at any stage of development. So, every single United States code, every single ruling, every single interpretation, everything that the United States does when they use the word person, they are talking about infants. This is all about the management of what? Of the estates of minors, otherwise known as infants. Persons of unsound mind, drunkards, spendthrifts, etc., by officers known as guardians, curators, tutors, committees. What? Like committees, right? Committees in the House, committees in the Senate. What are they doing? They're creating Roman civil law. They're creating statutes, acts, ordinances, and codes as public policy to administer the estates of infants. Persons who are incompetent to manage their own affairs have not free will, without which, as previously set forth in the text, there can be no property. Hence, as in the case of deceased persons, the law vindicates its character as such by supplying it with the content of its own universal will through the intervention of guardians. Now, I didn't put a note in here regarding guardians, but I'll mention it here. There was a time, several years ago, where I decided to go through every single DC code that had the word estate in it. Well, I pulled up 1,562 codes in the DC code that had the word estate in it. And I found some very, very enlightening things. One of the things I found that actually was stunning to me was the fact that I always thought that the United States Incorporated was acting as the guardian of all of the infants, of all the infants' estates. It's not. What's actually acting as the guardian of all the infants' estates are trust companies. And it said it right in the DC code. And I apologize. I didn't pull it up. I didn't have time to go grab it and pull it up. But I promise you it's in there. And the other interesting thing that it said in the DC code is that it takes 25 people to create a trust company. That number sound familiar to anyone? It's because it's the exact same number that they actually have to create a de jure grand jury. So what have they done? What has the attorney done? The attorney, behind the back of all of us, has gone and created de jure grand juries as being surety of the realm, and then created them into what? Trust companies that then have now managed all of the infants' estates through presumption of death and infancy and incompetency. That's what's going on in totality. Okay, so let's scroll back up to where I left off before I got to the notes here. So from this theory, it is apparent that the true reason for the law of descent, of the recognition of the validity of testaments, and the authority assumed by the law over the estates of deceased persons is to be found in the necessity of restoring the essential quality of property which has lost the will element by the death of the owner. Right? So the second that death kicks in, even if it's by presumption, your will is gone. You don't have one anymore. That's it. End of story. Until you correct it, which is what we do with the VSOF status doc set. We take care of that correction by doing a proper proof of life and proof of age inquest, which says, hey, wait a second. We've been found to be living. We've been found to become a full age. We're no longer an infant, and we've been found competent to handle our own affairs. So all these presumptions that you've been using, go fuck yourself, because they're not valid anymore. Because obviously, as per the Constitution, once a jury decides the fact about some matter, it can never be retried, except by the common law. So what they would have to do if they really tried to go up against this would be they'd have to go form a 25-member grand jury and then try to prove in some way, shape, or form that we were actually dead, or that we were actually that we had not actually come of full age, which of course they're never going to do. But that's the point. That's the reason why we do this. Okay. All right. To continue. Some text writers look upon the property left by deceased persons as res nullius, which might be seized and appropriated by the first comer or bystander, and hold that the laws of deceit and of distribution are simply wise and necessary precautionary measures to prevent strife and violence at the deathbed. That such is the effect of the laws as evident enough as also their wisdom and validity, but to place the reason of their enactment on this ground is to ignore the true nature of the family, as well as the true nature of property, meaning that you have the right to pass it on to whomever you will, and that the heirs have the right of first claim, not just whoever comes walking down the street. All right, Section 10, administration and functions of executors and administrators. The purpose of the law in this respect is accomplished in a simple and efficient manner by its officers or ministers. Just remember the minister part. That'll come up again. Vested with powers and duties commensurate with the exigencies requiring their intervention. The sum of their activity is called administration, which, in its narrowest legal sense, is the collection, management, and distribution under the legal authority of the estate of an intestate, again, one that doesn't have a will, by an officer known as administrator. Again, Black Grove Pre-Savelle. Semicolon. Or of the estate of a testator having no competent executor. Having no competent executor. Right? Get the point? This is going to keep coming up. They'll keep reminding you of the fact that if there's no executor, guess what? They're just going to administrate it. And a special little administrator is going to do whatever he wants to with it, including hypothecate it. But anyway, by an administrator with the will annexed. The person charged with the management and disposition of the estate of the testator is an executor. And his office is called executorship because he executes the testator's will. But his official acts are also called administration. So, yes, you're the executor, but yes, your official acts are the administration of the estate. But you are not an administrator, you are an executor. Okay? So that gets a little bit confusing there, but just know that. All right? The functions of these officers are in many respects similar to those of trustee as known in chancery. All right? Surprise, surprise. Text writers find it convenient to subsume them under the same class when discussing the powers, rights, duties, and liabilities of trustees. But there is an obvious and essential distinction between administrators and ordinary trustees. While the latter, ordinary trustees, derive their powers from the voluntary creators of the trust, the authority of the former, administrators, flows directly from the law itself. Right? Not from the will of the testator, but from the law itself. So whatever the judges and the attorneys want to do, basically what the ecclesiastics have been doing for thousands of years, which is saying we're going to administer the property of the dead. All right. Their functions constitute an essential element of the law and are exercised with entire independence of the personal views, desires, or intentions of the parties concerned. Sounds about like what they do in court, right? They don't care what anybody else says. Well, when they've got all this wrapped up in this presumption, they don't have to. Anyway, to continue. They are, in the full sense, officers of the law and of courts organized and having jurisdiction for the special purpose of aiding and controlling them. They are clothed with authority to act in all matters connected with the disposition of the decedent's estate, precisely as he himself would rationally have done. And it is the office of these courts to compel such action and to cancel all capricious, willful acts inconsistent with justice and the legal rights of creditors and distributees. Okay, so if it's inconsistent with the legal rights of creditors, right. So 14th Amendment, the debt of the United States shall not be questioned. Oh, and now we're all going to somehow have to pay for Congress's debt. No, fuck you. That's not how this works. The debt isn't ours. The debt is Congress's, not ours. And what they've been doing since 33, and a little bit before that, ever since the registration of infants' estates started, what they've been doing is they've been using the productive value of our estates to set off that debt. Well, it's about time that we take all of our estates back, and so that they don't have any of the credit anymore. That's what needs to happen. If everybody would take back their estate tomorrow, the United States Federal Corporation ends tomorrow. Full stop, end of discussion. And that's how we're going to save the Republic, because we're just going to wipe away the fiction. We're going to wipe away United States Incorporated by taking everything back of what is owed to us as being the sole lawful heir, and taking all of our allodial lands back, but that's a subject for another time. But we will get into that later on in here if we got time. So we might get to that, because there is some discussion later on in this treatise about the difference between title and fee and allodial title. Okay, so anyway, to continue. Section 11. Functions of courts controlling the devolution of property. The organization of courts having exclusive jurisdiction over matters pertaining to the administration of the estates of deceased persons and of minors, infants, and persons incapable of managing their affairs, has undoubtedly proved exceedingly useful and convenient to the public, but not necessarily the private. But while to this circumstance may be ascribed their historical development and the modern growth and increased extent of their jurisdiction, extreme increased extent of their jurisdiction as far as I'm concerned, yet the true distinction between them and the courts of ordinary plenary jurisdiction is not found in their usefulness or convenience, but is based upon the more profound principle underlying their origin, the logical, and I wrote this down because I'd never heard this term before, diremption, which is a sharp division into two parts. So logical diremption, which is logical splitting into two parts, of the functions peculiar to the two classes of courts, which in brief examination of these functions will readily disclose. The division of these powers of government into their constituent elements, resulting in all modern free states, right? So this is an aspect of the different magistries, known as the executive, legislative, and judicial. It is sufficient for the present purpose to bear in mind that it is the office of the judiciary to interpret and apply the law established by the legislative branch to cases arising out of collision, whether actual or imaginary, with the law. To cases arising out of collision, whether actual or imaginary, with the law. So now we have imaginary collision with the law. Yeah. Also, like a lot of presumptions that you happen to be using to totally fleece all of us. I would call that all imaginary as well. But anyway, to continue. Leaving it to the executive branch to carry out the judgments of the courts. Thus, the judge is seen to act as the organ or mouthpiece of the law, announcing in each case brought to his official cognizance whether the alleged collision between the will of an individual, as objectified, is an outward act for will which is undermined, not become external by accomplishment of its purpose, is beyond the realm of the law, which deals only with the actual. Okay, so if you're going to only deal with the actual, then what are you doing here? So basically, if you failed to create your own will and make it known upon the public record, there is nothing that the actual realm of law that can be acted upon, right? So they're telling you, that if it, and this is the attorney being extremely difficult to read and sneaky, but it's important to understand what they're talking about here. Okay, so whether the alleged collision between the will of an individual, so that's you doing what you're doing, and when they're talking about collision here, they're talking about you doing something unlawful, right? So whether the alleged collision between you of the individual is as objectified in an outward act for will which is undetermined, right? Okay, so this is hard to read. So for will which is undetermined. So a will undetermined. So someone who has not decided what the fuck their will is, right? So for will which is undetermined, not become external by accomplishment of its purpose, is beyond the realm of law, which deals only with what? With the actual. So if there's no will, there's nothing for them to function on. So what are they going to do? They're going to bound around and just be an administrator of the estate. And I know that was extremely difficult to wrap one's head around. And if you guys need to, go back and reread it 4 or 5 times, because I had to before class to even figure out what they were talking about. But that's how the attorney likes to write when they're really trying to fuck with you. So just know that. But that's what they're saying, okay? So they're saying that if you failed, so basically if no will exists, the law can only deal with the actual. So if not, it's real or imaginary. Okay. So in the exercise of this function, the judge will, a directness peculiar to the branch of sovereign power, accomplishes the great office and the end of the state and of all government, the accomplishment of justice, the realization of will, securing to the rational will of the individual its legitimate fruition, and holding the irrational, capricious, or negative will to its own logical result, reparation and punishment for a wrong and crime. Okay, so this is, they're talking about what, it's like an actual crime. So you go and you steal from someone. Okay, fine. Right? That's reparation and punishment for the wrong and crime, because you did something against someone by your own will, which then was proven in a court of record, which then shows that you were guilty of doing something instead of being innocent. Because innocent is one that did not have the will to do something. That's being innocent, right? All right. But we have seen that all property subject to administration is deficient in that element, which alone can be the basis of a collision between the individual will and the law. It is the province of the court having jurisdiction over executors and administrators to supply the individual will lacking in property, to fill the vacuum created by the death of the owner with the content of the universal will, that is, to secure the disposition of property under administration as the owner, acting rationally, would have disposed of it if living. So basically, this is a long-winded way to say that, yes, the court has to do these things with either executors or administrators to the disposition of property under administration, regardless of who's administering it, whether it be an executor or an administrator, as the owner acting rationally would have disposed of it if living. Okay, so who's the best one out of anyone in the universe to determine what one would have done with the property or the estate and how they would have disposed of it if living? Oh, that's right. The one that has been found to be living. The one that's just been presumed dead the whole time, but now has come forward as the sole lawful heir that's been found to be living. Well, guess what? Now my will is in full force and effect. And if you question that, well, then guess what? I've also appointed myself as my own executor. And that's the point. It's all about everything. And we certainly covered this in the first episode. So if anybody hasn't watched the first one of these, please go watch the first episode, because it all talks about the importance of the will. That without will, there is no property. So to continue, the functions involved in this office have a ministerial element superadded to their judicial quality. What? I'll read that again. The functions involved in this office have a ministerial, a minister, element superadded to their judicial quality. They act as black robe priests of El under ecclesiastical law, determining the property of the dead, which is where probate started way back in England. It started with the ecclesiastics taking control of that jurisdiction of law, okay? And they're still doing it, but no one's paying attention to it, which is why they all wear black robes. If they weren't all constantly acting in probate, maybe one of them might decide to put on a blue robe from time to time, or a white one. But no, they all wear black because they're all sitting there in probate. All right, to continue. Which, if they concurred in ordinary courts of law or equity, would require the intervention of adjuncts, commissioners, auditors, referees, etc., involving, aside from the question of inconvenience, delay and cost, and incongruity in the duties of the office. Such being the logical basis and scope of courts having control of executors and administrators, their historical development in England, but more particularly in the United States, has been a gradual but steady separation from the common law and chancery courts, and has resulted in a practical recognition of probate jurisdiction as a distinct and independent branch of the law. Well, fuck you too. So they've been moving everything back under probate, under the ecclesiastical jurisdiction for many, many years. And this is one of these paragraphs that when you read it, you can read the hubris of the attorney in this paragraph as to what they're doing. So I'll reread it and I'll put some emphasis on it with my tone here. So hopefully you guys can get it. Okay. So such being the logical basis and scope of courts having control of executors and administrators, their historical development in England, more particularly in the United States, has been a gradual but steady separation from the common and chancery courts, and has resulted in a practical recognition of probate jurisdiction as a distinct and independent branch of the law. Well, show me in any of the constitutions, state or federal, where it grants probate as its own jurisdiction. I don't see it anywhere. Do you? Well, then what are they doing? They're just making it up as they go. They want to take everything back under their ecclesiastical, filthy-ass priests of El, which is exactly what they love doing and exactly what William the Conqueror did after 1066. He separated what? The spiritual and temporal courts. He gave all his powers to his little priests, his little black robe minions, his little ecclesiastics, cults of Rome, to deal with the property of the dead. That is probate. That's where it stems from. That's where it came from, and they want it back. And God damn it, they've gotten it back because no one is paying any attention to what they're doing. All right, to continue. Designated to achieve for itself a sphere sui generis, meaning just out of fucking the thin air, just because they decided, just out of thin air. Sui generis, boom, here it comes. Based upon and determined by its own inherent principles. Right. You're just making it up as we go. That is literally what this paragraph said. And if there's one paragraph in this entire treatise that pisses me off more than any other, this is it, right here. This is the one. Because they're laughing at you. They're laughing at you when they write shit like this. But no one's going to bring this to anyone's attention except someone like me who actually goes through these things, tracks down treatises specifically to what they're doing, and then brings them to you. And then tells you how important they are. I can guarantee you no attorney knows any of this. They just follow whatever they're told by the judge. They don't know. They don't know what they're doing. Judges know because they're the one that create their 501c3 private religious nonprofit slush funds as their retirement. Why are they doing that? Well, because they're running everything through ecclesiastical law. That's why. And they're just administering everybody's shit. Because no one is claiming their estates properly. Okay? So there's my rant on that paragraph. Okay. Now, number 2, I don't know where this was number 2. Okay, so number 2 is here. So the functions involved in this office. So number 2, it's down here. So such as the appointment of administrators, granting probate of wills in non-contentious cases, qualifying executors, fixing the amount and passing upon the sufficient of bonds and sureties, receiving inventories, settlements, reports, etc., fixing the dividends to be paid to creditors, decreeing payment of legacies, ordering distribution of the residue. By the way, this is everything, what I just read here in the note, the number 2 note. This is everything that an executor should be doing. But it's talking about what the court basically does. So the functions involved in this office of the aspect of what they should be doing as far as the executors and administrators, what the court then says, okay, you guys go do this. Well, qualifying executors. What does this mean? There's one last handout that I'm going to open up here real quick. Okay, so let's open up the probate procedure. So the probate and solemn form. Okay, so I put this together. This is just kind of some notes of mine as far as what will eventually have to happen as far as the actual settlement of the estate and the various different ways that we might have to go about doing it. But one of the most important ways that I think it'll probably have to end up happening is that we'll have to open a probate case in solemn form. So it's going to be probate, not in common form, but solemn form. And so proof of solemn form definition. The pronouncement by a court that a will is formally approved and not subject to later contest, barring fraud or the discovery of a latter will. So it'll be absolute once this is done. Okay. Now the other thing that will happen when this goes through, what we will move the probate court to create or do is that we will make sure that they create a proper letters executor from the power of the court, which will have our seal from our court of record on it. Okay. So that's kind of what I was searching for, but I don't think I have it in here as far as the letters executor. So anyway, but I just wanted to bring this up and you guys can feel free to read this. And by the way, at the bottom, which I won't get into, but at the bottom here, I grabbed a whole bunch of the rules from Supreme Court rules regarding the definitions. And some of these are very interesting. Administration means administration of a deceased person's estate and includes administration with the will annexed and administration where a prior grant of probate or administration has become inoperative, and limited and special administration. So these are all things that they're doing to control our estates. And there was something else in here too that was interesting to me. Oh yeah, foreign agent means probate or letters of administration granted elsewhere than in New South Wales by a court of competent jurisdiction referred to in Section 101 of the Probate Administration Act of 1898. Whoa, excuse me? Granted elsewhere than in New South Wales. Where the fuck is that, guys? And why are we talking about New South Wales? And by the way, this isn't the first time I found something really weird about some other location.
Australia.
Well, okay, but it's not the first time I found something really weird about a location in probate. Particularly, I found some really weird shit in DC probate code as well. But so anyway, I'm kind of digressing here. But anyway, you guys can read the rest of this and understand that the reason I put this together was that so that it was to understand that we're going to have to do a probate in solemn form. So that's what we're going to want to be doing. But so anyway, so one of the points of that, one of the aspects of when we do it, it will be the qualifying of executors. We can just have the court seal the one that we already created and make sure that the magistrate signs off on it. So once the power of the court is affected by going through solemn probate, then we can take that letters executor to any place we want. We can go to the DTCC, we can go to the Secretary of State, we can go to the Treasury Department, we can go to Fidelity, and every other single court and every other single Secretary of State that has ever had any administration of any part of our estate and say, give me a full accounting. Because I am required to have a full accounting now that I'm the executor of the entire gross estate. So that's just the part of the qualified executors. Okay, so moving on. All right, chapter 12. Distinction between movable and immovable or real and personal property. All property of whatever kind or division is necessarily determined in its devolution upon the death of the owner by the same imminent law or principle. There is no inherent difference in this respect between corporal and incorporeal, or between movable and immovable property. All alike passes accordingly to the will of the deceased owner, whether expressed by him or presumed by the law, meaning being by the special administrator because there is no will. But the difference existing between movable and immovable property with respect to the feasibility of its actual transfer or delivery from person to person and from place to place gives rise to an important distinction to be observed both as regards to formalities necessary to constitute a valid testamentary disposition and as to the code of law which may govern the descent. It will appear from the consideration of the subject hereafter that immovable property must be determined by the law of the place where it is situated, but that movable generally descent according to the law of the owner's last domicile. So what I put in here, basically, this is the reason why I think it's so important to learn everything that we can about the DC probate court and to learn all the rules thereof, because even though the aspect of something that's immovable, meaning land, that would be dealt with the place where it is situated, meaning the Republic of Wisconsin or Illinois or Texas, whatever. But that movables generally descend according to the law of the owner's last domicile. If indeed we are all considered to be in this state, and in this state always means District of Columbia, and that if we're all presumed to be residents of District of Columbia, my guess, my logical deduction tells me that at some point we're going to have to break down and take a look deeply into the DC code, particularly everything to do with probate and the DC registrar of probate. And we might have to, and it might just be a good idea, and this anybody could do this that already has their doc set done, because it's not gonna hurt or harm anything. I would suggest that everybody that does have their doc set done track down the DC probate registrar and file the entire status doc set into and onto the DC probate registrar, which I don't think anyone has done yet. But I would be very, very interested to see what happens, and maybe somebody might actually get a letter back directly from the registrar saying, hey, now you get to do XYZ, or hey, now you need to go, whatever, or we have acknowledged the claim upon the estate which is sitting here, or God knows what they might send back, if anything. I'm not saying there's going to be a guarantee that they will send anything back, but no one's done that yet. So perhaps filing the entire vocational science freedom status doc set onto the DC probate registrar might be a critical thing that we might have to do, just simply because of what it just stated here in this sentence. And I'll reread it to emphasize again. So it will appear from the consideration of the subject hereafter that immovable property, meaning land, must be determined by the law of the place where it is situated. Again, like Wisconsin, Illinois, Texas. But that movables generally descend according to the law of the owner's last domicile. So if we're all considered to be domiciled in DC, it's going to have to go through probably the DC probate court. But so that'll be something that we're going to want to check into, and that particularly the committee, the VSOF committee for arbitration and control of public trustees, and for the estate forum in general, meaning the settlement of our estate. So basically committee 3. And the subcommittees under that. So the subcommittees of service of process, the estate forum, anything to do with Sestuke Vi stuff that we may need or may not need, possibly with dealing with the DC probate code or the DC probate court. So these are the things that we're going to be wanting to look into as far as the committees are concerned, that will track down the rest of this stuff when it comes to DC probate. Okay, so to continue, the most important classification of property giving rise to far-reaching and radical distinctions at the common law and in most of the states is its division into real and personal, corresponding substantially but not precisely to immovable and movable property, or to lands and tenements on one side and goods and chattels on the other. The importance of this division grows out of, or is at least enhanced by, the introduction of the feudal system into England after the conquest. Right, and that's referring to, as I always bring up, William the Conqueror in 1066 and everything he fucked up, right? Okay, which puts an end to all absolute ownership in land, and thus did violence to the principle upon which property rests. And this was all the aspect of the Doomsday Book, and that he forced everybody to register their lands, right? Okay, so that's where all this shit comes from, and which we now have in the current form of the Torrens registry system. The same thing under Roman civil law filth that this asshole started way back then, but it's morphed into that. Okay, to continue. The feudal system has so thoroughly permeated the common law and so thoroughly given it form and color that neither this nor the statutory system of England or America can be understood without a knowledge of and continual reference to the feudal principles. Well, I'm going to take argument with that in a second. And brief outline of the origin and history of the tenure by which land is now known is held in England must therefore precede the further consideration of the subject. Okay, 13. And I guess I'll do 13 because I got to dovetail into this, or else it's not going to make any sense when we come back. All right, 13. Origin of the tenure of real estate at common law. The peculiarity of the feudal system consists of the division of the ownership under the property as well as dominion over all lands in England was originally in the king, who granted out their use on condition of certain services to be performed. So this is an aspect of use and usufruct that was started by William the Conqueror, who did all this. Before it was allodial, which we'll get to. Okay, so this holding or tenure was not limited to the first or paramount lord and his vassals, but extended to all whom such vassals parted out their feuds to their own vassals, thus becoming mins, or what that word mins means middle lords between the latter and the lord paramount, which is the king. It became a fundamental maximum and necessary principle, though in reality, Blackstone a mere fiction, which of course that's the point, because these are all fictions upon fictions upon fictions. That the king is the universal lord and original proprietor of all lands in the kingdom, and that no man doth nor can possess any part of it but what has mediately or immediately been derived as a gift from him, the king, to be held upon feudal services, right? So again, this right to use, but not absolute ownership, because absolute ownership in land is a allodial title, right? And I think that I was going to skip down to, I was going to skip down to here. Okay, so the ancient English tenures, as described by Bracton in the time of Henry III, as of 4 kinds, which he calls knight service, fee scoage, pure villanage, and villian scoage, all of them being condition of service, duties, and burdens more or less oppressive. But they were swept away in the course of time with all their heavy appendages and all tenures in general, except frank, almerage, grand, so I always screw that word up. It's like sergeancy, I think, and copyhold, reduced to one general species of tenure called free and common scoage, by which all freehold lands in England are held to this day. Okay, fine. So that's England. So free and common scoage is England, but it's still based on what? Based upon feudal tenures. Number 14, substantial abrogation. Okay, so this is where I think I skipped, and I think I skipped down to, 15. Okay, so, okay, so this is where we get into it. All right, 15. The devolution of real property to the heir or devise, and of personal property to the administrator or executor. The common law of England took form and growth under the influences of the feudal system in its original vigor. Feudal principles constitute one of its essential features and determine wholly its policies in respect of real estate. Okay, fine, great. However, whatever rights of ownership are now enjoyed by English landholders have been granted by acts of Parliament, in degradation of the common law as well as in conflict with feudal principles. And my little note here is, in America, our lands are allodial, but I'll get to this in a second. I'll come back and read this. Since at common law, no English subject could hold land allodially. All right, make a note of that. That's important. Since at common law, no English subject could hold land allodially or in absolute ownership, but held it upon condition of rendering service and duties, like, I don't know, paying property tax, some of them being military, hence excluding from a genuine feud all infants, women, and professed monks as incapable of bearing arms, and under purely voluntary grant, dilli est contestis, from the feudal lord, it follows that feudal grants could not be taken for the debts of the tenant either before or after his death, nor devolve by succession upon his heir or devicee. Now, the aspect of the importance of the feudal part of it. So in America, our lands are allodial. This is what is stated in the Vocational Science Freedom of Declaration of Allodial Lands. And this is directly out of the Declaration of Allodial Lands, by the way. So, and this is one of the clauses in it. So therefore, the below signed people hereby invoke and activate with full lawful force and effect the Constitution of the great state of Wisconsin, specifically, jointly, and severally, Article 1, Section 14, that states, quote, all lands within the state are declared to be allodial and feudal tenures are prohibited. That's what it states in the original Wisconsin Constitution. And by way of that, from an aspect that what one right one people has in one state, you have the same rights in other states, right? That's a protection of the aspect of the federal constitution. Okay, so if you have the right to have allodial land in Wisconsin, guess what? You have the right to it everywhere. But you're not exercising it because you are registering your land under the Torrens registry system and acting as if you owed or rendered or service or a duty by paying property tax. As if you were a merchant here temporarily as not someone lawfully domiciled, but as someone who is a resident doing business here, that eventually when they're done doing business, they'll go back to wherever the fuck it is they came from, right? That's a resident. So instead of being lawfully domiciled and having a allodial title, you're considered to be a resident. And where's the presumption that you're a resident? Oh, that's right, DC. That's a problem, right? So we take care of this with the declaration of allodial lands, coupled with the fact that you have standing to declare to be allodial lands because you are no longer an infant and you can actually hold title. Because no one can hold allodial title who's an infant, because that's the ultimate absolute ownership. As it says, since at common law, no English subject could hold land allodially or in absolute ownership, which is what allodially means, right? Okay, so to continue, nor had the personal representative of a decedent feudal tenant in the slightest claim to or interest in the fee held by the decedent, for the fee reverted to the lord, neither creditors nor next of kin thereto, and if it passed to the heir, it was not by descent or in the right of the ancestor, but by a renewed grant from the lord, meaning we'll now let you use the land as long as you pay us a tax or go to war for us or whatever the case may be. And how's the system in America running? Oh, only if you transfer a warranty deed and you promise to pay property tax by signing the warranty deed. It's the same thing, but they just trick you into it by contract instead of by, feudal tenure. But it's the same goddamn thing. Okay. So feuds became hereditary. So that's you're passing the right of use onto the next son, whatever. And the unconditional descent of lands from the ancestor to the heir was secured by a statute which abolished the Court of Wards and Liveries. Okay, remember, you guys should know about the Court of Wards and Liveries because I talk about it quite a bit. Okay, so when they abolished the Court of Wards and Liveries by statute of wardship, liveries, premier season, and values and forfeitures of marriage and all this other stuff, right? Knight service and whatever. So this statute operated as a confirmation of title in the heir, but creditors were not allowed to subject lands in the hands of the heir to the satisfaction of their claims against the ancestors. Subsequently, executors and administrators, whose principal function it is to pay creditors out of the estate left by decedents, had no interest in or duties with reference to such lands. The law subsequently gave recognition to the rights of creditors in a series of statutes, culminating in William IV, which makes real estate of a deceased person liable for simple contract debts, as well as for specialities. Now, this is slightly different here, because if you have a homestead, particularly if it's, say, a widow's homestead, you can't go attaching debts to the land, to the homestead. It's not allowed. Okay. But thus a number of statutes and tenure of English landholders was made equal in every practical respect to absolute ownership, investing the tenant with all the rights and subjecting him to all the duties of allodial owners, while the common law in its forms of procedure in the nature of remedies and defenses according to litigants and the principles governing its technical construction is feudal in its theory. So again, they're talking about common law being feudal in its theory, and that they say, in a sense here, that the English landowners then got allodial title, but trust me, they never did. The only people that have the right to allodial title are we, the American people, as far as I know, anywhere on the planet. And anybody could correct me if I'm possibly wrong with some proof to the contrary, but I'm pretty sure that's the case. Okay, so this dual nature of the English law sometimes produces antagonism between its content and its forms, and thus violates in its provisions the strict requirements of logic. Yeah, no shit. A notable instance of which may be found in the rule that the legal ownership of personal property descendants to the executor or administrator, but that of real property to the devisee or heir. The rule arose out of the feudal tenure of lands which could not, as above shown, go to the personal representative because neither the creditors nor the heirs had any right thereto. The gradual conversion of this tenure into an ownership possessing all the essential qualities of property, except the name removed from the foundation of reason of the rule. But the rule remained a form void of essence, a body which the soul has fled. Now, this all gotten taken care of, like I said, with literally the Wisconsin Constitution. And I also believe that I think the Oregon Constitution has something directly in it also with allodial title. And yes, also that's true, Todd, verified the definitive aspect of the Treaty of Peace as well. So we were separated, charters were annulled, we're over here, you're over there, we can do whatever we need to do as far as our allodial title is concerned. So, Okay, so incongruity of the rule in America. The common law distinction between real and personal property is still recognized in most of the American states. And with it, the doctrine I think that's a misprint. So with it, the doctrine that real property descends to the devisee or heir and personal property to the executor or administrator. This doctrine was received along with the common law of which it forms a part. Its incongruity more conspicuous in a country in which feudalism has never obtained foothold, together with the attempts made in many of the states to abolish or modify the rule as inconsistent with the true theory of property, has produced much confusion and inconsistency in the decisions of the courts of the several states touching the law of real estate of deceased persons. Really? Well, there would be zero inconsistency in the decisions of courts regarding real estate if all the people made sure that they held their land in titles and allodium, as it states in the Wisconsin Constitution. This is what the attorney fears the most: absolute power of all the lands in America in the hands of the people. And notice there's no mention of allodial title in the constitutions in this paragraph. In fact, the attorney's trying to state the opposite. It has produced much confusion and inconsistency in the decisions of the courts of the several states touching the law of real estate of deceased persons. Bullshit. That's because you, the attorney, have been trying to fuck it up ever since we decided, no, we have a allodial title. Well, they don't like that because they don't get their 33%. And that also means that they can't interplead. Now, this is another term that I did not look up today, but if you want to, I highly suggest that everybody go look up the term interplead. Go look it up in Black's. I'm not sure if it's in Bouvier's, but I'm pretty sure it's in Black's. Go look up the term interplead. And what it means is that the attorney gets in between an heir and their estate before they can claim their estate. Well, what are they doing? Everything that the attorney is doing is interpleading. Everything. Every case, even a traffic case, I don't give a fuck what it is. That's what they're doing. They're interpleading. So if we would stop allowing them to interplead and get in between us and our estates, we'd have a allodial title to everything. Not only our lands, but also our bodies too, right? There wouldn't be any presumption that we have to keep getting marriage licenses because we're two infants having to get permission from daddy to have what they call issues, which are what they call the children, which is ridiculous. So, but anyway, to continue. All right, thanks, Rounds. Yep, interplead. The common law as well as... What? Go ahead.
Real quick, I want to jump in on the marriage thing. It's also a three-party thing because that it gives the state claim over the fruit of the union.
Right, which is the actual definition of...
It makes it a party to the contract.
Yep. And I think we actually have... Somebody put that into the memes. I think it's in the law memes media, actually, that somebody actually dropped that into there about what marriage is. I think somebody actually put it in. I could be wrong, but I thought it was in here somewhere as to somebody dropped it in there as far as the definition. And that is exactly what it says. It says that marriage is a union between basically three people, the husband, the wife, and the estate. There it is right there. Okay. Yep. There it is. So right there, marriage is a civil contract to which there are three parties: the husband, the wife, and the state. A status based on public necessity. Yeah, bullshit. But yes, that's exactly correct. So yeah, that's an important part to know that because that's exactly what they're doing. Because Caesar wants to have the productive value of every single issue that comes from every single marriage, right? So that they can continue to hypothecate and continue to draw off the productive value of all of our estates and continue to create credit off of it, which is how the International Monetary Fund works with their special drawing rights. And it's also literally how they create Federal Reserve notes. Same damn thing. It's this aspect of fiction of credit, but it's all based upon our productive value, but it all leads back to that marriage contract. And obviously the abandonment of the children at the Foundling Hospital as well, which is where they get all these presumptions from. So to continue. Okay, so the common law, as well as the statute in England enacted before the settlement of the colonies, is not only the basis upon which the new states built up their own systems, obviously like Wisconsin, but was enacted as law in almost every state, introducing, save as against affirmative legislation modification, the feudal principles which it embodies. And again, no mention of a allodial land clause in the Wisconsin Constitution here either. So the attorney's just kind of continuing to fumble along here without ever bringing up the fact that, yes, there are states of which lands are allodial. These principles are so interwoven with common law jurisprudence that to remove them would destroy the whole texture. Bullshit. It seems to be so difficult indeed entirely to eliminate our codes. Our codes? Yeah, that's right. Just caught you there. The attorney says, our codes, those rules and doctrines which constitute an essential element of the common law, but which grew out of conditions utterly different from our own, that but few legislatures have undertaken the task of building up a purely American system. Well, no, the legislatures didn't have to. The people did with the constitutions themselves. See how the attorney's like trying to make it sound like, well, the legislature just won't do any of this stuff. Well, it's made up of attorneys. Of course, they're not going to do anything to help anyone, right? But they don't have to because it's directly in the constitutions. But anyway, and what efforts are made by legislatures in this direction are often thwarted by the conservative spirit of lawyers and judges construing American statutes from the standpoint of the common law. Well, that's just doublespeak for we're not going to help you, right? So this simply goes to show, and this is my note over here, it says it simply goes to show that the attorney will take whatever position will give them the most power over others. And always remember that this is a treatise, obviously written by an attorney, right? So here he's arguing that, well, they can't do that. And even if they did do that, then the lawyers and judges would, in construing the statutes, they'd go to the common law side to not allow the aspect of what? Allodial title to reign, right? So again, it's difficult to read this shit, but when you've read enough of it like I have, you can see not only where they're trying to patronize you, but where they're specifically trying to confuse you in what they're doing. So anyway, in some of the states, however, the distinction between personal and real property as affecting the course of its descent has been entirely abolished. And in most of them, the common law rule more or less modified. These attempts to adapt the common law to the condition of things in America, which the legislative and judicial authorities of each state proceed according to their own views of the policy demanded, for the interest of its citizens, either restraining the common law or modifying it to a greater or less extent, or cutting loose from it entirely, have resulted in a bewildering labyrinth of conflicting decisions, not only among the several states, but in the states themselves. That's the attorney basically right there saying, it's so confusing, you'll never figure it out unless you come to one of us. No, fuck you. We're going to do a declaration of allodial lands, and we're going to stand upon it. We're going to take it off the public rolls, and it's never going to be taxed again. And the next person that it goes on to is whatever heir we decide it's going to go on to by direct descent. That's how it gets taken care of. Got it? Good. And that is the end of that chapter. So I'll make a note here. We'll come back, and so we'll do title the first next time we come back here. And is there anything anybody wanted to comment on, mention, or because I know I was reading pretty quick there through most of that, but if anybody wants to add anything or ask a question, feel free.
So what's going to happen when we all file at the same time and somebody in the District of Columbia starts to actually legitimately work on this and they try to figure some way out to sort of keep us from having what is ours?
Well, it's funny you bring that up because I have heard through various different, grapevine, either clandestine ways or whatever, that in some weird sense, they are waiting for us to do this so that we can have the standing necessary to do what we should have been doing all this time, which is doing the grand juries and cleaning up everything, getting rid of it. And basically, I mean, if you look at what the Luciferians are doing anyway with their system, they're collapsing their whole entire system anyway. The whole thing's done. It's completely disintegrating itself into oblivion. And you'll see that with the financial crisis that's going to hit probably the next 1 or 2 years. But hopefully we can get all this done and go back to sound money and say, okay, fine. That was stupid. Let's not ever do that again. And then we can get rid of the Federal Reserve and all the rest of the crap, including United States Incorporated as a whole. And just everybody go back to what we should be doing, which is being a de jure citizen of our own republic and one of the people thereof, and so on and so forth, and being pretty much protectionist as far as our own betterment is concerned, because globalism's done. If anybody doesn't know that, just go watch a few Peter Zeidan videos and you'll find that out pretty quick. In fact, the interview he did with Joe Rogan was fantastic. He basically laid it all out in about 2 hours. But so all that's done. So I keep hearing that they're waiting for us to get this finished. They're waiting for us to do it. This is something that we should have done a long time ago. And so that's what I've been hearing. But I've been hearing that for years too. And it's not just in America. It sounds like Daddy State is pretty much done all across the world. So it's either this weird sense that we're either going to get this done, move it forward, and we're going to change the world as to what it should be, which is predetermination of the individual sovereignty and freedom, or everything's going to keep going the direction it's going to go, and it's going to revert to the Luciferian filth, and you're going to have, Davos and those morons telling you to eat bugs, and you're not going to own anything, which is pretty much where the case is at the moment. You don't own anything until we get this shit corrected. So that's my 2 cents on it. Does anybody else got anything? Or because I have this on, you guys have to use push to talk. So as long as you set up push to talk, make sure that you just push down your button. You can unmute yourself and talk.
Was there a document that didn't get posted?
Possibly. Let me look in the folder again. We went through the vocabulary. No, it's just the second part of the administration, which we haven't gotten to yet. So this treatise is 2 volumes. So it's just the other part of the administration, which I can just throw into chat if you want it. But it's also in the mega link also. But we won't get to that for quite a while. Even if depending if we ever do get to it, because I'm probably not going to be as extensive as going through the totality of all this treatise as I have been in the beginning of volume 1. I'm going to be much more selective as to going through the rest of this, most likely, because it is a very, very large treatise when you put both of these volumes together.
Yeah, I thought you said something about notes.
No, this was everything I had in the folder. The 2 sets of the treatises, the vocabulary words, the probate, which is the probate notes, which I said, oh, maybe I didn't drop that in the chat though. Sorry. Okay. So that might've been the other thing. And then, just the definition of administrator and executor. Oh, who is they? Waiting sounded? No, waiting meaning like the white hats of the Republic, and the people that are supposed to be, doing the right thing as far as our nation is concerned. But that's who I was talking about, quote unquote, waiting.
People that are loyal to their oath.
Right. Yep. It's a good way of putting it. They're waiting for us to move because we're the sovereignty. We have to do this.
What about the states that don't appear to have any mention of a loyal title?
Well, again, like I said, that's the connection to the federal constitution, where it states that, those that I forget the exact clause. It's the
Equal Protection Clause.
Yeah, thank you. Yeah, that states that if you have a right to do something in one state, you have the same right to do it in another state. And we've used that too, because we filed the Declaration of Loyal Lands in obviously other states than Wisconsin. And
emancipation was nothing but nationalization of the slaves. That's why they had to create U.S. citizens.
Yeah, that's true. Yeah, good point.
I'm familiar with that.
Yeah, 14th Amendment bullshit. Yep. Which is kind of not stuff we haven't already covered, obviously.
That was in response to Greatly Love's comment.
Oh, okay. Oh, yeah. Okay. Yeah, exactly. Yeah. The question was, just for the record, in case anybody's just listening to this. So the question was a simple question. Could or would being emancipation as a minor on the record into adult help any of this? And the answer is basically no, because the presumption of the infancy is paramount to what they're doing on everyone. Could an emancipation possibly do something? Well, maybe, but it wouldn't do anything to claim the estate of which they're administering. That's the problem. And yeah,
it doesn't matter if they're emancipated or not from the state's control. They're still lord of the state.
Yeah, exactly. And you're still a guardian of the trust company of which is administering the estate as well, which is most likely the DTCC. So, so even childhood emancipation wouldn't alter nor fix the totality of the system of what they have above you and over top of you. And it's because of what Jonathan Todd said. It's because you need a will, because your will has already been probated because the presumption of death was there in the beginning. No one came back to claim you. You were abandoned at the hospital by document. Dad never had the sense to come claim you at the hospital, which, by the way, the announcement in the newspaper is basically their way of giving notice to say, hey, a baby boy has been born, or a baby girl has been found. Sorry, go ahead.
Interesting thing is that they gave me the option when my kids were born whether to do the birth announcement or not. We did not, so nothing was published anywhere about it.
I mean, you're still going to do you're claiming them anyway through the status doc. So, but yeah, I said okay. So, given title as an adult can't help if you haven't claimed will. Well, you don't get no one has their title until they've rebutted the presumptions that the attorney is using against all of us. So the presumptions are death, infancy, abandonment of your own estate, competency, and there's other ones like that you are a citizen of the United States, that you are federal personnel, meaning that you're having a social security number and you have a social security account. And there's a few other ones, obviously being a citizen of the United States, being subject to the jurisdiction of Congress, all that shit. So all those things have to be rebutted. So it's not just, there is no silver bullet. It's not just one thing. It's a multitude of things that all have to happen pretty quickly at the same time. And Sounder, as far as critical mass is concerned, no, not really. I mean, there isn't necessarily any special number. I mean, if I were to put a special number on it, I would say 25 people per county that were out that had grand juries established. If I had to put a special number to it, that's the number I'd put to. So there's 3,500 counties in all of America, something like that. So it'd be 3,500 times 25, whatever that is. That would be your critical mass number, I guess, if you really want a number. But of course, it would have to also be organized into that aspect. I mean, not totally, though, because here's the thing. Once enough people get out and we're all together, and it's probably going to be mostly people that are either listening to the VSOF or other people that are trying to do what the VSOF is doing, but are listening to us and might get, certain parts of it done before we do or after we do, whatever, it doesn't matter. That as a whole, as an aggregate whole, they're going to look at it and go, okay, there's now enough people that are out that the Republic is now, or they could consider the Republic to now basically be repopulated to a certain extent. But I don't know that for sure. It's not like I've got, some letter from a white hat stating that's exactly what they need, but it certainly feels like that's what needs to happen. So
this is technically hearsay, but somebody was trying to say that the military had told them that they needed 16 people per state to make them stand down from the military or the martial law rule.
Yeah, it would kind of make sense. Like I said, I think 25 technically is the proper number because that would be the only proper. And that's weird that somebody said 16, because 16 is usually the number that a lot of these states have been creating their quote unquote grand juries by, like the number 16, but not all. But that's kind of weird. So I would say no. If you really truly wanted to get done, it would be 25 in each county. And yeah, in a sense, that's what Anna Von Dipshit. But she thinks she can do it for everyone. She can't. Everyone has to claim their own estate. No one can do this for you. Okay? That's why what she's doing is absolute bullshit, because no one can come in and just snaggle up everyone's estates and go, okay, now we're representing you. No, sorry. That's no different than what the attorney's been doing for a couple hundred years.
No,
Fuck
she's
that.
fucking, that makes her executor dissentart.
Exactly. That's a crime. Yeah, that's executor de sentort. That's a crime, what she's doing. So, yeah.
Drop the grand jury handbook.
Yeah, and wait, what? What about grand jury handbook?
I said you should drop it in here since we're kind of heading in that direction.
Well, it's not done yet. So there's a couple people that are going to help me finish up the grand jury handbook as far as editing is concerned. Amura said he wanted to help out. So he's the only one that has the totality of the grand jury handbook at the moment. Beside, I think I gave you a copy, CLF3, but I'm not sure. But I'm going to keep that under wraps until we get.
Did years ago, but I don't know.
Okay, I probably got an updated version. So we've got to get that edited and finished up before I want to give it out to anyone else, or give it out to everyone, which I will do when it's when it's finished up. But yeah, I have a whole grand jury handbook. I think it's over 280 pages. It's probably going to be a bit bigger before we're done with it. And it'll have all the information on how to operate a grand jury and all that good stuff in it. So yeah, so that's something I intend to get done before the end of the year, as long as Amora and I can get it finished up. So, okay. So with that, we're well over time. So we've gone about an hour and a half. So I think we'll keep it here. I made a note in the treatise where to come back to. So we'll come back to part first, come back to of testamentary disposition of property. And like I said, I'll try and make a few notes and we'll skip around and get through the rest of this as fast as we can. Keep learning the ways in which they are administering our estates without our consent. And so I'd like to thank all of you for coming, participating, hanging out. And we will have our open roundtable this coming Wednesday. So until next Wednesday, everybody enjoy the rest of their weekend. Thank you for coming, and stay safe and stay sovereign.